have a list of everything that the panel took into account before coming to that conclusion?
It is a ruling of the panel that we are here to question. And the ruling in its terms is what is before us. Obviously, I'm not in the minds of the panel, and I'm not able to divine whatever went on in their minds, except by reference to the terms of the ruling. And my lords, in any event, Order 38, Rule 3E5 has nothing whatsoever to do with application of the Evidence Act, Section 26. Order 38, 3E5. It reads as follows, that is, as amended by CR 87. If a party who has served a witness statement does not call the witness to give evidence at the trial, or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. That provision has nothing to do with the Section 26, which the court was stating emphatically is not applicable because of this order. The terms of this order are themselves very clear. They do not have anything to do with what Section 26 says. What Section 26 says is, again, not controversial. What Section 26 of the Evidence Act says is simply establishing a conclusive presumption in a circumstance where somebody has put before the court clear indications by way of affidavits that she will be available to be cross-examined. That leads to what Section 26 describes as a conclusive presumption based on the estoppel by own statement in Section 26, except as otherwise provided by law, including a rule of equity, when a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest, and such relying person or his successors in interest. Order 38, 3E5 has no relevance in terms of that. And our submission is simply that the court cannot sideline the operation of a statute by reference to subsidiary legislation, which in any case has no relevance to the issue of Section 26. My lords, we indicate in ground C, in ground D, so we've dealt with A, B, and C. We indicate in ground D, we take B and C together. And I argued in relation to B and C that the fundamental errors consist of sidelining legislation in favor of subsidiary legislation, and in relation to ground C, sidelining it in favor of subsidiary legislation which is irrelevant to the issue in the statute anyway. And so we move to ground D. And in ground D, our submission is that here again, the court made no reference whatsoever to Order 38, Rule 10 of CI 47, nor indeed Section 58 of the Courts Act. And Section 58 of the Courts Act is a section which even gives power to your lordships to call a witness. And that section has been properly applied. So in other words, apart from our ability to subpoena upon reopening of our case, apart from that, there is also the opportunity for this court itself to call a witness. And the circumstances in which the court does that, those circumstances are exemplified in the case of Wardier and Bukhari. Wardier and Bukhari, 1976, 2 Ghana Law Reports, 371, where the Court of Appeal, the then Apex Court, proceeded as follows. And this is from the judgment of Justice of Appeal Archer, as he then was. After judgment had been reserved in this court, it was felt that this court should not be placed in the same situation in which the court below found itself. It was therefore decided to ascertain the truth in this matter, and so on. And based on that, the court had recourse to the Courts Act to ascertain the truth of the matter. And then the court went on to point out that just that invitation of the witness to come and testify had brought up a very important piece of evidence, which, if it had been adduced in the court below, would have spared that court the torment of exploring whether or not the certified true copy of the plan from the Lands Department was the plan tendered before Jackson J. And the court even goes on to say, one can understand Mr. Joe Rindolph's initial reservations, but as this additional evidence has enabled this court to ascertain the truth beyond all doubt, we think by allowing this additional evidence to be admitted, Mr. Rindolph conducted himself in the best traditions of the bar. Indeed, those words in respect of the best traditions of the bar evoke some nostalgia in the hearts of some of us. And my lords, we are respectfully saying that the ruling that your lordships gave did not even advert to Order 38, Rule 10, which we had indicated was the basis on which we were seeking to reopen our case. It didn't even advert to that, and it was therefore per incuriam. We say also in ground E, which I move on to now, that the ruling was per incuriam Article 1913 of the Constitution and has occasioned a grave miscarriage of justice. And Article 1913 is the provisions on the right to a fair trial in this court. And we show in our submissions on that matter how this Supreme Court adverted its mind to a decision of the Supreme Court of the Netherlands, in which the Supreme Court of the Netherlands was highlighting the importance of ascertaining the truth in matters that were before it. And that was made to displace, in the interest of the right to a fair trial, it was made to displace even international relationships as being something that the court would have reference to. That decision in the case of Chachuchikata and the Republic is a decision that we have cited in our submissions, and I will not go further into that except to underline the fact that the Supreme Court of the Netherlands, whose reasoning was adopted by the Supreme Court of Ghana, also considered it appropriate that in the interest of ascertaining the truth, it was of value to the court to call a witness.
Once again, I'm curious about something. If it was so important to you to have a particular person testify for you. Why did you not present that as part of your pre-trial positions?
My lords, we could not, for the reason that I've given a few times in this court. At the time, that first respondent's chairperson was the person who had filed a witness statement on behalf of, well, first of all, had filed an affidavit of verification of the case of the first respondent. Subsequently filed a witness statement on behalf of the first respondent. And my lords,
So in essence, you were hoping to rely on her coming to testify and found yourself without that. And that is why now you are asking that she comes as your witness after everyone has closed their case.
My lords,
is that what you're saying in essence?
My lords, what we're asking is for our case, for us to have leave to reopen our case. That witness, as we've indicated, had sworn affidavits in response to our application for interrogatories, in response to our application for stay in relation to that. And in those, she had given every indication that she would testify. We had no reason to believe that she wasn't telling the truth. We had no reason to believe that she didn't mean it when she swore those affidavits. We had no reason to believe that anybody in the court would have assumed other than that she would testify. In fact, the day that it was announced that she would not testify, on that day, your lordships themselves expressed, some surprise, and that was the reason why you adjourned to the next day for arguments to be raised and so on. So, my lords,
Mr. Chikata, when you announced that you had closed your case, what did you mean?
Nothing more, nothing less. We had closed our case. And when we announced that we are seeking to reopen our case, I mean exactly that, nothing more, nothing less. We are seeking leave to reopen our case in circumstances where a person who has deposed to affidavit saying she will be available for cross-examination, and where your ladyship specifically had intimated that the questions that we're seeking to raise in interrogatories could be asked of her in cross-examination. I'm sure your ladyship has not forgotten that bridge. And in that context, your ladyship had said that aren't we crossing a bridge that we have not got to? And we indicated that at the stage of interrogatories, we still found it appropriate to anticipate that. But your ladyship said the bridge will be there. That bridge is no longer there.
When you said that you had closed your case and you meant it, nothing more, nothing less, what did you mean?
I really don't understand what more your ladyship wants by way of an answer. We meant that we had closed our case. And we had closed our case, and subsequently we sought leave to reopen our case. Your ladyship cannot say that we are not able, under the rules, under your inherent jurisdiction, to ask for your leave to reopen your case. I don't believe that that is a suggestion that your ladyship is making.
I don't think I've said any such thing.
So, but it's very difficult to comprehend.
I just wanted to understand what you meant when you said you have
I've answered that question, I think, twice or thrice
nothing more,
already.
nothing less. And I'm satisfied with the answer, sir.
My lords, we continue finally to the last ground, that the ruling was in breach of Article 296. And my lord, very simply put, what we're saying is that that ruling is completely unreasonable in terms of what are often referred to as the Wednesbury principles. And her ladyship, Justice Georgina Wood, as she then was, in the case of TDC and Musa against Atab Balfour, 2005-2006 Supreme Court Law Reports, page 121. Your Ladyship's, her Ladyship, at page 131, expressed the specific terms of what such unreasonableness amounted to. And by saying that he, that is the plaintiff in this case, succeeded in showing that the case fell within the irrationality or unreasonable rule, in that the decision arrived at by the TDC defies logic and common sense or accepted moral standards, and that without meaning any disrespect to the TDC, no sensible or reasonable person called upon to apply his or her mind to the decision to be taken could have come to that decision. In short, the decision to throw him out of the house and foist a residential plot on him is irrational and unreasonable. And we are saying respectfully that your lordships, in the exercise of your discretionary powers, unfortunately failed to advert your minds to relevant statutes, introduced irrelevant considerations which prejudiced a fair exercise of discretion as required by Article 296 of the Constitution. It is our submission that holding the first respondent, and particularly his chairperson, accountable for the exercise of powers conferred by the Constitution and statute justify, in the circumstances of this case, that that chairperson be called upon to testify using the time-tested subpoena procedure that we seek to invoke in this case. My lords, there is no question that the process of review is among the ways in which corrections are made by your lordships. And as Aqua,
your time is up.
May I just finish in a minute, because I'm in the middle of a sentence. Is that allowed?
Okay. You may finish.
As Aqua indicated in the Koblex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.
Order in court, please. Order.
Yes. My lords, we are vehemently opposed to this application for review number 3. Lord, we have filed an affidavit in opposition as well as a statement of case, and we rely on it. Lords, under Article 33(1) of the Constitution, this court
may review 133.1, my lords, 133.1 of the Constitution. This court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of court. Also, even the Constitution recognizes the role that is played by the Rules of Court Committee. And indeed, my lords, the Rules of Court Committee passed the Supreme Court Rules 1996 CI 16. And lords, the specific rule on review is Rule 54. Lords, this court is the final court of the land. We concede that the court is not infallible. But, my lord, your lordships may change your mind in an application for review only when certain conditionalities have been met. My lords, those conditionalities have been set out in Arta number 2 versus Arta number 2 to 2013-2014, 1 Supreme Court of Ghana Law Reports 569 at pages 579 to 580. Lords, I will not read those conditionalities there, but they are there. Lords, it's only when those conditionalities have been met that the review panel should seriously consider the merits of the application. Lords, our submission that the conditionalities set in Rule 54 of CI 16 and ATA have not been met by the applicant in this application. Lords, with the greatest respect, the grounds are basically an academic treatise of alleged erroneous pronouncements made by your lordship panel of 7. Indeed, if we want to give some credit to the grounds, my lords, they are at best additional grounds that have been filed without leave of your court in terms of an appeal, but they do not form grounds for review for which my lords should grant this application. My lords, may I refer your lordships to the ruling that has generated this review at pages 11. With your kind permission, your lordships held, accordingly, in weighing the propriety of reopening proceedings to permit new or additional evidence to be led or tendered, the court will typically consider the following broad questions. 1. Will the evidence, if it had been presented during the trial, have had any influence on the result? 2. Could the evidence have been obtained before or during trial by the exercise of due diligence? Then your lordship conclude that in this application, the petitioner has not given us an inkling of the new or fresh evidence he wants to bring to the fore. Neither has he disclosed how that evidence would advance the cause of his petition. Lord, I believe that this is the crux, this is the ruling that the court made. And in the absence of any attack or any submissions regarding this application must fail. Lord, I submit further that the grounds are very misconceived and have no bearing at all on your ratio that I have set out above. Even as submissions were made by the counsel for the applicant, And even as I'm speaking, still, my lords, the court is still not aware. It still doesn't have the inkling of the evidence that the applicant wants to lead, for which the case should be reopened. And Lord, this leads me to the Wardier case that was cited by counsel for the applicant. Because in that case, the evidence was known. The evidence was that there was an issue about Exhibit A, and by agreement of counsel, the court then said that let an expert come and testify as to the authenticity of the document. So in that case, the court allowed further evidence just because the evidence that the expert was being called was known. This is not the situation in this case. Lord, what has been done is that there has been arguments that border on the nature of an appeal. Indeed, if my lords look at paragraph 3 of the affidavit in support, with your kind permission, if I may read, he says that at the hearing of this application, I shall, through my counsel, seek leave of this honorable court to refer to all processes filed in this case up to the date of the hearing of this application, clearly indicating to your lordships that he is going to argue an appeal. And that is why your lordships...
It is an application based on previous process.
Yes.
You see, so in motions,
yes,
what you try to do is that instead of seeking leave when you are on your feet, to refer to it,
yes,
you can capture it in the affidavit. Yes. So don't ask for this one.
No, my lord, if my lord could hear me on the point I seek to make is that as a result of that, the submissions that were, for example, dealt with on the 18th have been brought in. For example, section 26 of the Evidence Act was dealt with. That's the point I seek to make by referring to this submission. My lords, this court has said time without number that the review jurisdiction is not an opportunity given to a party to come and argue the case again as if the review panel is sitting in judgment on appeal over the ordinary panel. And this is what my learned friend has sought to do. Lords, may I crave your indulgence to refer to the Standard Bank Offshore Trust Company Limited versus National Investment Bank. Lords, in civil motion number J7/15/2017. Lords, Doche JSC, delivering the ruling of the court, admonished sore losers at page 17 of the judgment thus: from the ratio, with your kind permission, from the ratio of the decided cases of this court on review, it is immaterial if the applicant for a review considers the decision of the ordinary court to be wrong in law or has an emotional reaction to it, as in this case, the magnitude of the amounts involved or the shutting of the door to applicants because of the effluxion of time in instituting a fresh action. These are not factors that a review bench normally takes into consideration, my lords. Lords, in that case too, the court went on and held that the rules of the court forms an integral part of the laws of Ghana, and consequently they must be given an equal amount of respect in order to produce the sanctity in court proceedings.
Mr. Menuvel,
yes, sir.
Are you referring to me as a sore loser? I argued that application for review before this court. I was standing where you were some few years ago, and I lost that application.
Well, Well, my lords, the review panel forms that view of you. The review panel forms that view of you, my lord, and indeed of your client, my lords. My lords, incidentally, my learned friend was on the other side in that matter, and he got the review. Yes. My lords, the case of Mechanical Lloyd Limited versus Nati again is there on the point. Lord's arguments have been made in this court regarding fair trial. My lords, I ask just a couple of questions of the petitioner. This petition, my lords, has been conducted in a piecemeal fashion, which is one of the things that CI 99 deprecates. First, orders of the court are disobeyed. File, witness statement, no. You yourself intimate that I am going to call 5 witnesses. You call 2. And then you come back to the court, oh, my lord, I forgot one person, permit me. It is permitted. You call that person. Yes, my lord. Oh, my lords, this is the issue of fair trial. My lords, with the greatest respect, the issue of fair trial has been raised. And now I'm saying that he has been given fair trial in the way the case has been conducted, my lord. Lord, then we go from there to having called the 3rd witness. What is your pleasure? Oh, my lords, I close my case of your own volition. Lords, it is my submission, therefore, that the petitioner was given every opportunity. He was fairly heard in these proceedings. And what has been filed, review number 3, is an abuse of the court processes, and the application ought to be dismissed in limine.
Mr. Menuva, you have not addressed us on the reference to Hosea, the gospel according to Hosea. Yeah.
My lords, I made
order, please.
My lords, my point I wish to make on that, if you permit me, is that God is a God of conscience, and God does not use court processes to elicit conscience. No. God is a cause of conscience, and therefore you do not bring God into the courtroom to now claim that because of God, application should be granted. That's my response.
Isakutampo.
30 minutes.
My lords, we are opposed to this application, and my lords, we rely upon affidavits in opposition filed on the 21st of February, together with our statement of case. My lords, our first submission is that this application woefully fails to satisfy the conditions for the grant of a review application. As in our view, it does not demonstrate any fundamental error committed by the court which has occasioned the petitioner a miscarriage of justice. And on that ground alone, this application ought to be dismissed summarily. My lords, now on ground A, of petitioner's application, the petitioner refers to section 72 of the Evidence Act. Now, my Lord, section 72 of the Evidence Act reads thus. So it's 72 sub 1. Subject to the discretion of the court, in a civil action, a party or person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence. At any time, my lords, during the presentation of evidence by the party calling the witness. My lord, it is very significant that in his statement of case, there is a deliberate omission of the controlling word evidence by the party of evidence. That is, and I see no reason to believe that this was inadvertent, because it is repeated twice, and on both occasions this critical word is left out of evidence. Now, what is the significance of adding of evidence, reading section 72(1), including of evidence? It means that a party can only exercise that right when he has not closed his case. That's what it means. And I want to repeat this. Section 72, which appears to ground the backbone of this application, relates to a situation where a party has not closed its case. Now, in this instant situation, the party had closed its case. So the court had no business referring to section 72(1), because it was irrelevant to the circumstances of the case. And my lords, it is my submission that knowing that they had closed their case, the petitioner disingenuously omitted of evidence. And with all due respect, this is highly improper. So, my lords, all the submissions around section 72 that the court was per incuriam of section 72 are totally unmeritorious and irrelevant. Now, my lords, we proceed to deal with grounds B and C. And my lords, counsel for petitioner has argued that Order 38, Rule 3E, 5, cannot override Section 26 of the Evidence Act, because in his view, the Evidence Act is a substantive legislation, and Order 36 subsidiary. My lords, 38, sorry, is subsidiary. My lords, it may well be the case that Order 38, Rule 3E5 is a subsidiary legislation. But the point here, the critical point here, is that the very principal act, this is the Evidence Act, Section 26, by itself delimits the application of the main text by the words subject to a rule of law or equity. And my lords, there can be absolutely no doubt that Order 38, Rule 35 is part of the laws of Ghana. So it is because of the specific provisions of Section 26 that the court could then look at Order 38, Rule 3E5 and rely upon it in making its ruling. So, my lords, respectfully, I think it is misconceived to suggest that in doing so, the court had committed a fundamental error by allowing a subsidiary legislation to trump a substantive act of Parliament. My lords, we would next address Rule Ground C, which relates to Act 459, Section 58. Grandi. My lords, in my respectful view, Section 58 of Act 459 is completely irrelevant to the matters before the court. Because the matters before this court, which is the subject matter of the review application, relate to the court's decision not to reopen the case. My lord, that is the decision of the court. Now, Section 58 reads, in any proceedings and at any stage of the proceedings, a court, either on its own motion or on the application of any party, may summon any person to attend to give evidence or to produce any other document. My lord, this provision presupposes that the party who is applying to summon another has not closed his case. Now, this is obvious common sense. It is very clear that this provision cannot relate to a situation where a party has closed its case. And my lord, these are the ways in which provisions of the law have been persistently cited out of context. Perhaps to mislead those who do not know the law. So, my lord, it is our respectful submission that a reference to Section 58 of the Evidence Act, of the Courts Act, in this situation is totally misconceived and should never have been made by counsel. My lords, we wish also to make the point here, for the last time, that The chair of the first respondent has never made any undertaking that she would mount the witness box, such that the petitioner could claim that he relied on it to his detriment. My lords, all that the chair of the first respondent did was to repeat what the law is. That is all that he did. The law, and if your lordships go to order 22, rule order 22, all that the chair of the first respondent did was to repeat the position of the law, which is that if you fail to obtain interrogatories in relation to a matter, you may, during cross-examination, elicit the same information. That is all. It was never an undertaking, and it beggars belief that the petitioner and counsel are basing this statement of the law as an affidavit, an admission or a representation that they relied upon to their detriment. My Lord, I therefore wish to submit that a reference to the deposition of the first respondent's chair on this matter can never constitute an estoppel, because she has the right to refuse not to enter the witness box. And the court has ruled definitively on this. This application for review of the decision to reopen cannot be the back door through which that earlier ruling can be considered. The court has ruled on it, and that ruling binds all of us, including counsel for the petitioner. My lords, the fair hearing argument, my lords.
We have 5 minutes more.
Very well.
10 minutes.
My lord, I thought I had a lot more minutes. Unless your lordship thinks I've made out my case, so.
You have 5. Out of the 30, you have 5 minutes more.
Thank you.
My lord, ground E relates to the allegation of breach of his right to fair hearing. My lord, the right to fair hearing is a right that all parties to a suit are entitled to. So, the court has ruled that the respondents have the right to elect not to adduce evidence. That is their right under the law. Therefore, to seek to reopen your case so that you can compel the first respondent through his chair to enter the box is a breach of the first respondent's right to fair hearing also. My lord, it's our considered view that no evidence or analysis has been made by counsel for petitioner that sustains their claim that their right to fair hearing has been breached. Indeed, this court has been more than accommodating to the petitioner. They defied the court's order with impunity not to file witness statements at the time they were ordered to. They have even again defied the court's order to file closing addresses. And perhaps the court may once again accommodate their defiance of the highest court of this land. And then they turn around to talk about fair hearing. In our respectful view, their case should have been struck out when they failed to file their witness statements as ordered by the court. Or it could have been struck out. And as we speak now, since they have defied once more to file their closing address, this case can be settled without their closing address, and it will be fair trial. My Lord, I'm saying it will be fair trial for that to happen. Possibly the court is once again going to accommodate them. So they should be the last people to be mounting the high horse and talking about breach of their right to fair trial. My Lord, our respectful submission is that this allegation of breach of their right to fair trial is an invitation to the court to go on a frolic which has absolutely nothing to do with the issues before this honorable court, as to whether any person, any of the two parties, the petitioner or the second respondent, obtain more than 50% of the valid votes cast in the 2020 elections, presidential elections. My Lord, again, the reference to 296 is in our view quite surprising. Yes, my lords, the court was right in the TDC case to hold that the acts complained of were unreasonable and irrational. But my lords, in the instant application before your lordships, the petitioner has failed once again very badly to demonstrate the facts which ground the allegations of unreasonableness or irrationality. Because those facts, my lord, are based on the grounds that he has dealt with earlier on, A, B, C, D, which we have demonstrated to be hollow and of no merit. Accordingly, my lords, we believe that, and we submit that the application is devoid of merit. It is deserving of a summary dismissal, and given the fact that the arguments are only a rehash of earlier arguments and the introduction of irrelevant provisions for the consideration of this court, we pray that in this exceptional situation, this application be dismissed as an abuse of process. It be dismissed as an abuse of process and cause punitive costs.
Your time is up.
Malted. My lords, we are done.
Who's that?
My Lord, may I, with your leave, make a couple of brief references. My learned friend for the second respondent, I heard him a little while ago say that we are acting in breach of the right of the chairperson of the first respondent as far as testifying is concerned, as far as our indication that we are seeking to subpoena is concerned. And my Lord, as a matter of law, respectfully, it is not for the second respondent to bring up a witness's claim to immunity, whether on the basis of a right to fair hearing or self-incrimination or whatever. It is not for the counsel for the second respondent to bring up a witness's claim to immunity. The witness must themselves, that witness must, his or herself, I should say, his or herself, put forward whatever claim she seeks to make to immunity. And Lord, I believe that that was the reason for our reference to the case concerning the IFC's immunity and so on. And my Lord, counsel for the second respondent also sought to suggest that I had somehow sought to mislead the court in terms of section 72. Well, that's a very serious insinuation. Well, it's not actually an insinuation. It was a very express statement on his part. And my Lord, I can only say that counsel is obviously not clear about the nature of the application that is before you. Because the nature of the application that is before your lordships is to seek to reopen our case for the presentation of evidence. That's the nature of the application that is before you. So, reading section 72 about the presentation of evidence and making it seem as if what we are doing is somehow foreclosed because we have closed our case just shows that he hasn't understood why we are in court this morning. Because, my lords, we are in court asking your lordships to reopen our case so that we can go according to certain processes. That's what we are in court for. So for him to be saying that we are trying to mislead you by not referring to during the presentation of our case and so on, my lord, that is just a clear failure to appreciate the terms of section 72. And my lord, he completely does not address the point that we made, that section 72 was not even referred to by your lordships, and that your lordships ruling is per incurium of that section.
Are you done?
Yes, I'm done.
Yes, I have one question for you.
Yes.
Your arguments, you dwell mostly on section 26. Section 26 of the Evidence Act. Can you show me any conflict between section 26 and order 38? Is there any conflict between section 26 and order 38? 38 rule 3 E5. Is there any conflict?
My lords, I was referring to the fact that the ruling implies that there is a conflict, and that in the ruling it says this section is not applicable because of order 38.3e. And my lords will notice that I in fact went on to argue. I argued that rule 38.3e5 in fact has nothing to do with section 26. Your lordship will recall that I argued that. So I was specifically referring to what was in the ruling. The terms of the ruling are clear.
So it was not a matter of the court preferring subsidiary legislation to substantive.
That's what the court said. I mean, I read it. The court said.
No, we didn't say so.
We wish to state emphatically that section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38.
But it doesn't mean that the court was preferring or raising Order 38, raising 38 against above Section 26. That is not what we meant.
Well, my lords, I leave that to your lordships, but the language of the ruling is what I'm referring to. But I leave it entirely to your lordships. The language is that it is not applicable in view of something else. So that other thing is being made applicable, whereas Section 26 is not being made applicable. I mean, there's no running away from that. If you say this is not applicable in view of this, then it means that what is you say is applicable.
No.
You're setting aside.
That is what I'm not. It doesn't make it superior to Section 26.
Yeah, but my lord, how can your lordship say that Section 26 is not applicable in view of Order 38?
That is our view.
Yes, but my lords, and that was the other point I was going to make, respectfully, and I'm glad that it has come up. Reference has been made to your ruling in respect of another application in which you did seek to consider Section 26. And there we argued that no reference had been made. It was per incuriam Section 26. In that ruling, again, no reference was made to Section 26 at all. In your ruling in that case, your lordship said, effectively, yes, we didn't make reference to that Section 26, but we haven't been shown that a miscarriage of justice has arisen because we didn't make reference to it. And my respectful submission is that, and I did say so, that is itself fundamental error, and your lordship should take the opportunity to correct that error, because you didn't make reference to Section 26, and you sought to justify that by saying that no miscarriage of justice has been shown to you. And my submission was that when you don't apply a statute, there is no reason for miscarriage of justice to be a further ground.
Different from,
I'm sorry.
When you don't make a reference, it's different from not applying.
Well, my lord, if you don't even make a reference, you can't apply. I mean, if you don't even make a reference to it, you can't apply it. I mean, you make a reference to Black's Law Dictionary. Black's Law Dictionary, you make a reference to that. Black's Law Dictionary is not binding on this court. It's stating common law rules which have been changed by statute in this court. But you make reference to Black's Law Dictionary. But you don't make reference to the statute that is binding on you. Well, that is per incuriam. That's
No. That is your opinion.
well, that is indeed my opinion, and I think it's backed by a plethora of authorities of this court.
The court will rise to consider his ruling.
with me, Alexander Samoa.
If it pleases your lordships, I put on power for the second respondent. My lords, with me are my learned friends, Frank Davis, Kweko Sirifi, and Yao Pong.
We have before you two applications, one of which we've indicated we are withdrawing them. There's an application for stay of proceedings pending the review. The review has been disposed of, and we do not intend any further steps in relation to that application. We have an application for leave to file our closing address after the date that your lordships ordered. And in the affidavit in support, we've indicated also that we are withdrawing the motion for stay. Yes, my lord.
Lords, as regards the motion for stay, I have no objection to it being withdrawn.
Lords, the same.
By court, the motion for stay of proceedings is struck out as withdrawn.
Most graceful.
Yes.
As I move the motion for leave to file our address after the date ordered by the court, I move that application in terms of the motion paper and the supporting affidavit. And my lords, as we've indicated, the affidavit in support is sworn to by counsel in this particular case for obvious reasons that appear on the face of it.
My lords, we are opposed to the application. We are opposed to the application, and we are opposing it by virtue of Rule 69C of CI 99, and also, my lords, by reference to the case of Republic versus High Court, Tamale, ex parte Dapem Zobuguna Henry Kalim, civil motion number J5/6/2015, judgment of the Supreme Court dated 4th June 2015. Lords, in that case it was held that the bare fact that an application for stay of proceedings has been filed does not operate as an automatic stay, so no party has the privilege to stay away from proceedings as the applicant did at the court below. Lords, if we look at the affidavit in support, the applicant or the petitioner is brazenly telling the court the reasons why he has refused to comply with the orders of the court. When established practice and the decision of this court is that the mere filing of a stay does not amount or give you the right to stay away from proceedings, because this is the highest court of the land, and I think that obeisance to the rules and orders of the court are part of our practice. And insofar as the positions clearly show that yes, I chose not to comply with the orders for my own reasons, I pray that this application be refused. Your Ladyship, 69C of CI 16 as amended by CI 99. The 4B, Your Ladyship, with your kind permission, the court may dismiss the petition where the petitioner fails to file the processes regarding the petition within the specified time. Laws.
But we've had the case to conclusion.
Pardon?
I said we've had the case to finality. We are left with only closing addresses.
Yes, my lord, it's part of the processes that we file.
My My Lords, we are opposed to this application to the extent that the petitioner is not seeking the magnanimity of the court.
But what is he seeking?
He is asserting a right. My Lords, the petitioner, my Lords, if your Lords would refer to paragraphs 10, paragraphs 13, paragraphs 15, and paragraphs 14 of the petition. My Lords, of the affidavit in support. My Lords, the petitioner is seeking to tell the court what is convenient for it. So it says in paragraph 10, it would not be ideal for me to have to file a closing address without the testimony of the chairperson. In other words, the court has directed him on the 11th of February that we should all file closing addresses by the 17th. And he elects to tell the court that it will not be ideal for him to file, to comply with the court's order. On what basis can a party tell a court much more the highest court of the land?
It's coming from friend on the other side. No, it's coming from
my Lord.
That is the position in the affidavit you are referring to.
Yes. So, my Lord, I'm saying that this deposition is a direct defiance of the court's order.
For leave to file,
but it's in the leave, in the application for leave. It's an example of the defiance. My Lord, that's what I'm saying. That it is one thing for them to come to this court contrite, and therefore the court should grant them leave. But they are trying to justify what they did, their defiance of the court's order. So, my Lords, they may be advised to withdraw those paragraphs, offending paragraphs, and just plead to the court that they be granted leave. But this attempt to justify the unjustifiable.
So, comparing the only depositions, this is you are asserting, right?
Yes, because the application is based on the depositions. So they may choose to advise themselves and withdraw those depositions, of offending depositions. So that, because, my Lords, if this court grants this application on this basis, it will set a precedent. It will undermine the court's well-established authority that a review application is not a stay of proceedings. Secondly, that a party who files an application for stay is not entitled to stay until the court grants it. Those are two very important principles of this court. And if the court grants this application based on these depositions, it will be undermining those principles. So our view is that it's all fair for the court to grant the applications, but it cannot be based on these depositions. No, it cannot be. And finally, my Lords, they have arrogated to themselves the proposal of when they file. No, yes, I know that will be left to the court. But, my Lord, will you hear me out? They have already had, since the 17th, since the 11th, now it's about how many days? 11 days. And they're asking for a further 72 hours. Meanwhile, we, under pressure, have met the court's order. So if they are seeking the court's leave, they should be filing this thing either by the end of the day or latest tomorrow, my lord, because they have indicated to your lordships that they already have a draft. Yes, but my lord, again, like their samples, they are saying this is a draft, so that it will give them the opportunity to go and produce something completely different from the draft.
Order in court, please. Order. My lords, I will not dignify some of the comments on our conduct. My lord, there have been very serious comments made about our conduct, which I will not dignify with a response. I will not dignify them with a response, because saying that we filed something and then we'll go, I mean, these are serious allegations, but I do not wish to dignify them with a response. That's what I wish to say. I only wish to say respectfully that we have come to this court asking for leave, and in indicating that we are seeking leave, we have adverted in our affidavit to certain factual realities that we have had to deal with. Those factual realities include the fact that we have filed applications for review before this court. Those applications have been heard by this court and they have been dismissed. But we could not have contemplated that those applications would necessarily be dismissed, because we did not believe that there were predetermined outcomes for those applications. That was not the basis on which we proceeded. We did not believe that. And because we did not believe that, we took our time to deal with those review matters in the hope that after the review, we might have the chance to have a witness testify. The court has this morning decided, or this afternoon, the court has this afternoon decided.
My lords, with all due respect, my lords, he can respond on points of law at this stage. No, please, my lord, that is the process I mean.
Please, if the bench wants to say something, you defer to the bench, please.
Very well,
Mr. Kutempa, before he could move the application formally, I had wanted to know whether any of you were opposing it. It is normally done in practice just to, as to manage time. So, well, I anticipated that, this is a colleague on the other side who has sworn to an affidavit explaining his inability to do that. He has annexed a proposed, normally we call it a proposed, not a draft, a proposed statement of case or whatever. So I thought that you were not going to oppose. That was why I cut him short and decided to ask whether you were opposing it or not. It is normally done.
Very well, my lord.
Yeah.
And my lords, in the affidavit in support, these clear circumstances in which we have found ourselves have been put before you. As a matter of fact, the paragraph 10 that counsel for the second respondent found so offensive. My lord, with respect, there is no offense to this court in the lawyer saying it would not be ideal for me to file a closing address without the testimony of the chairperson and then have to file a separate further component of should the review application be so. That is a very simple statement of the reality that we find ourselves in. So rather than get into all these things, we have given an indication to the court. And we say in paragraph 13, the deponent says in paragraph 13, I will crave the indulgence of the court to allow. We did not arrogate to ourselves a time frame. The position is very clear. I will crave the indulgence to allow, and this just gives an indication to the court of a time frame within which it will be feasible to file. How can anybody interpret paragraph 13 as imposing on the court or as not being, as not recognizing what the court's authority in this? The very heading of the application is motion for leave to file, and therefore we do not see any problem. But most fundamentally, we respectfully say, as in paragraph 15 of the affidavit, there will be no prejudice to the respondent by the grounds of this application, especially as they ultimately elected not to adduce evidence in support of their case. So, my lords, we have not had sight of whatever they filed anyway, because I believe the registrar may have been under some instruction, but the registrar did notify us when he was serving other processes that that particular process had been filed but not served. That was notified, and we have not sought to have that because we don't need it. Our legal arguments are not premised on what they have said. Our legal arguments are very clear. And your lordships may note that we call it a draft, my lords, for a very specific reason. Because it is not, as is clear on its face, it is not yet complete. It is very clear it is not complete. In fact, there are gaps in places where certain things are meant to be included. It's very clear. And so, my lords, we've indicated there's a draft, and we've indicated a potential time frame within which the lordships may be willing to grant us the indulgence of filing. And therefore, we respectfully seek the indulgence that we have asked for in our application to enable us to file our closing address. And my lords, may I finally say that when we stand here at the bar, we stand here as officers of the court. We stand here as officers of the court seeking to help the court advance the interests of justice. And in that regard, I believe that a closing address that presents to the court the case of the petitioner in its entirety is something that will be beneficial in the interest of justice.
Mr. Chikata, how do you reconcile this prayer that you are now making to the earlier statement which you made when you were on your feet, that you did not know that there were predetermined outcomes? I heard you clearly.
No, Mr.
Chikata, can you listen to me? When there is intervention from the bench, you have to listen. That is a practice we know from the bar. I heard you. I may not have heard clearly. But what I heard is what I'm asking. Now, how do you reconcile this with the earlier statement that you made, that you did not know that there were predetermined outcomes to the applications that you had filed? That was why you did not file your address.
Yes, my lords, what I
did you say that there were predetermined outcomes?
My lords, no, I did not say it in the terms that you have put it. What I said was that when we made our application for review, we expected that application to be successful. We did not know that there would be a certain outcome. And my lords, we can plead and
Mr. Chikata,
but my lord,
you use the word predetermined.
Yes, my lords, I use the word in the context
if you can explain.
Yes, my lords, I use the word in the context of stating that what the outcome of that was not known in advance by us. So it was not, in our minds, it was not a predetermined outcome. That's the point I was making. For us, it was not a predetermined outcome. That is the fact. And that is what I said. That is what I said. And I believe your Lordship has just indicated that that's how you understood what I said. And if your Lordship understood it differently, that's certainly not my intent. I stated clearly that for us, it was not a predetermined outcome. And so we could not have, on that basis, prepared a closing address without reference to the potential of that witness being called. We could not have done that. That's a clear indication. And my lords, I mean,
by court, we are of the opinion that the petitioner should be granted leave to file his closing address on or before the close of Tuesday, the 23rd of February 2021, in the interest of justice. Yes. Yeah.
We're grateful.
Yeah. Yes. The petition is adjourned to the 4th of March 2021 for judgment.
My lords, I was actually going to make a preliminary before your adjournment. Is it possible that I may be heard on? Because my lords, in terms of the filing of the addresses,
yes,
I was going to respectfully draw your lordship's attention to the fact that there had been an earlier indication that you would provide a time for oral highlights of, my lord, may I respectfully May I respectfully finish? That time has passed, I'm aware of that. But, my lords, in the light of the new orders, I was going to respectfully ask that after we have filed our written address, an opportunity may be available for your lordships to seek any. My lords, in the petition of 2013, there was an opportunity provided which enabled certain important legal issues that had been raised in the written addresses to be addressed by the bench and the council on both sides. And my lord, I believe that even if it's, you know, for a half hour, as the timekeeper has been rigorously insisting, that enables, you know.
We have indicated that we are adjourning for judgment. Now, if we, upon reading your closing addresses, think we want some clarifications, when they come to you, but otherwise, we have adjourned for judgment. Very well.
Order in court. Order, please. Lords, writ number J1/5/2021, Article 64 of the Constitution and Supreme Court Rules 1996 CI 16.
My lords, I take it that you are done with our matters. Very well.
As amended by.
There is a contempt proceedings which the court
as amended by CI 74 and CI 99. Amended presidential election petition. Presidential election held on 7 December 2020. John Dramani Mahama versus Electoral Commission of Ghana. Nana Adodankwa Akufo-Addo. Dr. Dominic Akurutinge Ayeni, contempt. Lord, contempt present.
Oh, please, yes. Are you represented?
Yes, my lord.
The council, may you respectfully announce yourself?
Frank Beecham appears for the contempt with Kokobram Labi and David Beecham.
Yes. Miss Ayene. Sorry. Honorable Dr. Ayene. Please, you have been summoned here by this court to show cause why he should not be committed for contempt. Yes, because on the 16th of February 2021, we made certain statements which were very, very scandalous of the court.
Sorry.
Yes, we have exercised restraint in invoking our jurisdiction to always be committing people for contempt for obvious reasons. The other time, I think you were here when I drew the attention of Mr. Frank Davis. I think so also, yes, Lawyer Pong, then Marietta, the former learned Attorney General. I drew the attention and they stopped. But then, from nowhere, you also jump onto the fray and you made certain scandalous statements which the bench thought that it was least expected of somebody who held a very high office as the leader of the bar when the Attorney General was not present. The Bar Association is just an association, but the Attorney General is the head of the bar. Yes, in every common law jurisdiction. So that is one of the enviable positions at the bar. Yes, I know the lead counsel was a president of the bar, but Attorney General, somebody who has acted as Attorney General, is the head of the bar, not the Bar Association president. And we want you to tell us whether you did say those words. Then you proceed from there.
My Lord Chief Justice, I did say those words. My attention was drawn to the fact that I might have crossed the line by Mr. Frank Davis, and Your Lordship, on the advice and consultation with my counsel, I have written to the court rendering an unqualified apology. I delivered that letter this morning to the Registrar of the Supreme Court to bring it to Your Lordship's attention.
We have copies of the letter and we've circulated it. Yes, we are comfortable with the apology, but we want to make certain consequential of this. Yes, Mr. Bicham. Yes, you can be heard.
Yes, my Lord. With respect, our client has no excuse. Personally, as lead counsel for him, I was very disappointed at the article that I read last week and was deeply distressed when he called me last night. And I thought it was because I had made certain disparaging remarks expecting some action to stop this canker in the profession. It was to tell me that he had realized the error of his ways and pleaded for me to join him to render an unqualified apology to this court. He makes no excuses for that. He admits he is wrong and has been wrong. He deeply regrets the harm done to his profession, the disrespect shown to the court and to also to the country. I have his instructions to render his unqualified apology to every member of the Supreme Court and indeed the judiciary of Ghana and the legal profession and people of Ghana that he is awfully sorry for what he has done. He is deeply remorseful and he deeply regrets what he's done. So, my Lord, our prayer is, yes, true justice has to be done, but we ask you to temper justice with mercy.
You are a former president of the Ghana Bar Association, is that right?
That is so, my Lord.
I have been worried for some time now, listening to people granting interviews to the media, and not any ordinary people or lawyers, but people who have occupied very high position in this country. And we have to decide where we want to go as a country. In my view, the only reason why Article 88 of the Constitution, or the only ministerial position which is provided for in the Constitution, is that of the Attorney General. is that when you are appointed an Attorney General, you are appointed an Attorney General for the whole country. A party or a president may appoint you as Attorney General, but once appointed, you are the Attorney General for the whole country. And you are to ensure that every citizen of the country is given justice or has access to justice and fair trial. So when I hear former Attorney Generals and Deputy Attorney Generals mount or grant interview and make certain statements aligning in no uncertain term to one political party, it's something that worries me. And as a former president of the bar, I think you have to open a debate in that area about the proper role of Attorney Generals or former Attorney Generals, having regard particularly to Article 88 of the Constitution 1992.
None of respect.
Two lawyers to support you. What we can do for your client is to let him go back and purge the contempt. Yes, he spoke to the whole world on television. Yes, he should tell the people that he's very, very sorry. What he did was wrong, and that is all. We are not going to find him, we are not going to give him a bond, but at least coming from somebody who has acted an Attorney General, if we don't take any action, it is going to send dangerous signals elsewhere. That is all what we want to do for him. So if he does it today, the court will assemble on Thursday and just strike out this matter. That is all. We are not exacting any serious punitive measures against him. All what we want to do is for your client who has confessed to whatever he did to he just go and apologize for the harm that he has caused to the profession and to the bench. This is our profession. Nobody can come from elsewhere to make it better. Yes, beyond the lawyers, nobody can come from elsewhere to make it better. Yes, we can make it. And it is a duty which has been imposed on us by our call. Yes, so please, let's all cooperate. At times you hear some comments by lawyers and you feel that they are killing the profession, because a time will come when nobody will come and sit here as a judge. Yes, we posted one judge to ECOWAS court as a high court judge. He's not the president. Whereas the other countries posted their Supreme Court judges there. A high court judge from Ghana was the president there. But this is something. We have the Court of Appeal judge here. He sought the leave of the Chief Justice to take an outside appointment. He's the Chief Justice there. And no matter what we do, please, the profession first. Yes, the profession first. And we should endear ourselves to the respect and whatever it will take to bring the profession to its past glory. So we thank you very much for not dragging this matter and coming with an unqualified apology. So that is what the bench has decided. We don't want anything from the former Attorney General, Deputy Attorney General, but all what we want is the retraction, yes, an apology, yes, through the same medium, and that will end the matter. If he does it, we'll come here on Thursday and have it struck out.
Because we are very grateful to you for this indulgence, and also taking the cue from the point made by my Lord Amugati, whose views I share personally, on a personal basis. And I did indicate to you why I stepped in, because I was even more worried when he called me. I thought someone had accrued that I had made disparaging remarks about his comments, but that's the point. But the right to be done, Lord. And we are profoundly grateful for your indulgence and promise you that even before we came here, we have started a process of showing remorse and regret. Most grateful, my lords.
I will say something because Dr. Aine is a friend and a brother to me. I know he is a member of parliament and therefore a politician. But he should know how to talk when he is addressing the press as a lawyer, and then how to talk when he is addressing the press as a politician. They are two different things, because I know when politicians mount the witness box, they say anything, they can say anything at all. Then at the end of the day, when they are recorded, they come to deny. I've been a politician before. I know how it is. So you should know how to talk as a politician and then how to talk as a lawyer. They are different things altogether. It's like we've been insulted, judges are insulted by people who know nothing about the law, and sometimes who know nothing about the issue that is before the judge. And they talk and insult. If they are not lawyers, we don't care. Because if you don't want to be insulted, you cannot be a judge. But if you are a lawyer and who knows the law and who knows the procedure, and then you talk, in a manner, that does not speak well of you as a lawyer, it gives opportunity to non-lawyers to also talk or say worse things. So that's my advice to him as my brother. I'm a younger brother.
You know what you have done? I remember when we went to the country. Ask him. I called him, and he was prepared to go to the news file to explain what obtains at the various faculties and why people should pick and choose and put their wards and children there to study law, not any faculty without lectures and whatever. And yes, the bench approached you, and you did it for us for free. Yes, so these are some of the things that we can all, do to help the profession. It's nothing more. Yes.
So we are really grateful, and thanks for that.
And just one more thing from me. Dr. Aine, as a former Attorney General, I have sat with you on the Judicial Council before. The two of us have joined to even appoint justices of the Supreme Court. You know the challenge, the difficulties, what we went through to appoint justices of the Supreme Court for this country. So after serving the Republic in that light, it's improper for you to go and make those statements to give the impression that the justices make decisions based on certain things. That's why some of us are disappointed at that statement. But having rendered this apology, we know, as my brother Justice Apau said, sometimes out of some kind of excitement or so, you are forced to make certain statements. As we've said here, we all make mistakes. We are human beings, and once in a while we cross the line, we make mistakes. So I'm happy that at least you've realized that what you said was overboard and you are prepared to retract it. But going forward, let's remember that we have one country and we all have a responsibility to keep this country together, no matter the circumstances and the situation we are confronted with. Thank you.
Lord, we are grateful for the admonition. I promise you, this will not recur. I'm grateful.
Yeah, my court.
Yes, my lords, with all due respect.
Yes.
My lords, before this matter commenced, your lordship mentioned my name. My lord, with the greatest of respect, with all respect to this court, I just want it to be placed on record that I have not said anything to scandalize this court. I believe that...
I didn't say so. What I said was that when we started the proceedings, you were granting interviews, and we drew your attention to the new legal profession ethical rules. Yes, we drew your attention to it, and you were advised to stop, and you did.
My lord, your lordship, I no doubt dispute that.
Yeah.
But I think before the proceedings,
I never said you.
Something was said to that. Myself and.
Yeah. And
my lord, if that is the position of the bench, I'm exceedingly grateful. I don't want my name to be associated with scandalizing this court. As a former president of the Great Accra Bar, the longest serving president of the Great Accra Bar,
and the most populous bar.
Yes, and the most populous bar, arguably. Justice Amigachi is not looking at me. I was the Mugabe of the bar, and I remain so. Yeah. I'm grateful.
Yeah.
I'm grateful.
I thought you were the Nkoswaini.
Yes, Prof, you can call me that. That was conferred on me by the Sanzania Amisha as a Nkoswaini of the bar, so I still remain.
And we take this opportunity to also thank you for your end of year dinners for the bar. For the bar and the judges.
So far as that is concerned, Justice Apo can bear ample testimony.
So thank you.
With my eloquent service of blue label Scotch whiskey.
Thank you. Yeah, thank you. This is the order of the court. We accept the apology of learned counsel for the contempt law. We, however, order that the contempt law purges its contempt by retracting the scandalous statement on the very same medium before Thursday, the 25th of February 2021, when the court will reconvene. The contempt proceedings is thus adjourned to Thursday, the 25th February 2021 at 9:30 a.m. So, Mr. Bicham, so you will come here 9:30. If he renders the apology, you will come and completely vacate the order.
My Lord, just for some clarification.
Yes.
I don't believe we are expected to be here on Thursday. No, we just want to be, yes. Very well.
If you want to come and show solidarity, you are invited, you are at liberty to attend.
So. Rise.
petition hearing. He joins us once again. Good afternoon to you, Doc.
Good afternoon.
Right, it's been interesting in court. By way of telling us what happened, can you just briefly take us through what's been happening after we went for that break?
All right, so the first thing that happened was that the court gave its ruling, and until we have the certified true copy of the ruling, we will not be able to delve into detail because we just had the Honorable Chief Justice read out the ruling. But from what I heard, the ruling was to the effect that the petitioner had failed, first and foremost, to indicate the nature of the subpoena and the type of evidence that was to be adduced. And so the application was dismissed as not being supported in that regard by any law and settled practice. The court went ahead to set out or suggest that they had set out the boundaries in their 16 February ruling, the boundaries that must be complied with if the court were to or was to exercise its discretion to allow a party to reopen its case. And so they proceeded to set out the 6 grounds of review which the petitioner set out as occasioning a great miscarriage of justice, and proceeded to deal with them consecutively. So, for instance, the court disagreed in its ruling with counsel for the petitioner on the alleged fundamental errors that the petitioner was alleging the court had engaged in, and reiterated the fact that they were the highest court of Ghana, and their decisions are binding, their decisions on law are binding on all other courts in Ghana. And so they talked about also the interest of justice not being only the interest of one party, but in order to determine what is just regarding the duties of the parties in that particular suit. And so they set out the threshold once again that you need to meet when you have voluntarily closed your case, and then proceeded to deal with the issue of Section 26, the issue that had to do with the conclusive presumption that the petitioner was alleging that by virtue of statements or averments in the positions deposed to by the chairperson of the Electoral Commission, suggesting that the interrogatories or the questions contained in the application for interrogatories that the petitioner sought to serve.
Look, can just kindly hold on for us. We'll go for the press conferences from the two parties, and then we'll get back. So let's quickly move back to the forecourt of the Supreme Court for the press conference.
There's a certain page I have marked. Okay. 28 since April. Please, are we all ready? Okay. Good afternoon, distinguished friends from the media. As always, we are grateful to you for the opportunity to address the nation and by extension the world on the court's proceedings on the 2020 election petition, a matter which is of considerable public interest. Several things happened in court today, but the first was that counsel for the petitioner moved an application for leave or an application for review of the court's decision on 16th February, which is the court's decision on our application for leave to reopen our case so that we could subpoena the chairperson of the Electoral Commission to testify. Now, for those who are not lawyers, an application for review is a right given to any party dissatisfied with a decision of the Supreme Court to apply to the court and invite the court to respectfully review or change its own decision. And Article 1331 of the 1992 Constitution and the decisions of the Supreme Court has made it clear that you can apply for review of the court's decision, and in fact the court will review that decision where there are exceptional circumstances such as fundamental errors of law committed by the court which have occasioned a miscarriage of justice. And so today's application for leave that counsel for the petitioner moved was to achieve just that, to demonstrate to the court that in this decision of 16th February, certain fundamental errors of law were made, and to invite the court to remedy or rectify those errors by reviewing its decision in the interest of justice. Now, the grounds that counsel for the petitioner relied on in moving this application was that, one, you would recall that when counsel was moving the application for leave for the court to allow us reopen our case, he was asked in what capacity he was seeking to call the chairperson of the first respondent, and he answered by saying that the petitioner was going to call the chairperson of the first respondent, the EC, as an adverse witness. And so you would recall that in the court's decision, the court stated that in their opinion, it was wrong for counsel to have said that he will be calling the chairperson of the first respondent as an adverse witness because per the Black Law Dictionary, a witness can only be described as an adverse witness after the witness has entered the box. And if it is detected during the evidence in chief of that witness that he or she is giving evidence adverse or contrary to the case of the party examining him or her, then that witness becomes an adverse witness, and counsel can then apply to the court to treat the testimony of that witness as that of an adverse witness. That was the decision of the court. Now, ground one of today's application argued that that decision of the court was a clear fundamental error because it did not take into cognizance Section 72 of the Evidence Act. Section 72 of the Evidence Act is simple. It says that subject to the discretion of the courts in a civil action, a party or a person whose relationship to that party makes his interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination. And so if you are a party or you are a witness or any person and your interest in the case is substantially the same as a party in that case, then an adverse party can call you to give evidence. And so in our respectful submission that we made to the court through counsel for the petitioner, one does not have to enter the box before that person can be described as an adverse witness. And that Section 72 of the Evidence Act allows a party to call a person whose interest in the case is substantially the same as another party in that case as an adverse witness. And so for us, the court's decision for this reason was per incurium. Per incurium basically meaning that it was without recourse or it did not apply this section. And for us, this is a very serious fundamental error, because as the court itself has held in several decisions, the court is the servant of the legislature and must apply the rules or the laws that the legislature, passes. Then secondly, counsel for the petitioner argued that the court committed another fundamental error of law when it stated in its ruling of 16th February that Section 26 of the Evidence Act is inapplicable. It wouldn't apply Section 26 because of Order 38, Rule 3E5. And just to break this down so that those watching can understand, counsel for the petitioner has argued, and we have explained or elaborated that point here on several occasions, that for us, Section 26 establishes the principle of estoppel, and that section basically says that if through your acts, statements, or omissions, you intentionally and deliberately makes another person to believe a thing to be true, then the truthfulness of that thing must be conclusively presumed against you, that person having relied on that representation from you. Which basically means that if per your actions you make me believe that you will do something and I rely on that, the court should not allow you to resile from that position. And we have explained that. We are saying that G. Mensah, through her depositions in at least 2 affidavits before the court, made it clear that she will be available for cross-examination to answer certain questions. And so she's bound by Section 26 under the rule of estoppel to change her position. And in that ruling, the court said, because of Order 38, Rule 3E5, we will not apply this. And we, today, counsel for the petitioner respectfully submitted that that was a fundamental error of law. Because number one, Order 38, Rule 3E5 has got nothing to do with the principle of estoppel and a witness or a person being, being held by the court as bound by a previous representation. That order has to do with a party having the rights not to call a witness who has already put in a witness statement. The purpose for us relying on Section 26 had nothing to do with the party. It had to do with G. Mensah as a person. And so for us, that was completely irrelevant. And counsel for the petitioner further argued that even if there was any relationship between Order 38, Rule 3E5 and Section 26, Order 38, Rule 3E5 could not be interpreted or construed as having precedence over Section 26, because in the hierarchy of laws, a constitutional instrument is subservient to an act of parliament, and Section 26 is provided for in the Evidence Act, which is an act of parliament and which is superior to Order 38, Rule 3E5, which is a subsidiary provision made by the Rules of Court Committee. Again, counsel argued that the court did not take cognizance, or the court did not apply Order 38, Rule 10 of CI 47, which counsel indicated to the court that he was going to apply should leave be granted for the petitioner to reopen his case. He said, I will follow this rule, Order 38, Rule 10, which is basically the rule or the process for the issuance of a writ of subpoena. And that the court's decision did not make any reference, not only to Section 72 of the Evidence Act, but did not also make any reference to Order 38, Rule 10, which we had indicated that we were going to rely on to subpoena Mrs. G. Mensah. Then he spoke about Article 19.3 and Article 296 of the 1992 Constitution. And Article 19.13, has to do with an adjudicating body acting independently, impartially, and ensuring that a case brought before that body, is conducted in line, fairly, in line with a fair hearing. And in our opinion, counsel for the petitioner submitted that if you look at the way the court has failed or refused to apply certain statutes, and the court appears to be shielding, in fact that is in his statement of case, shielding the EC chairperson from accountability or testifying, it is not fair, and it violates the petitioner's right to a fair hearing as stipulated under Article 19, Clause 13 of the 1992 Constitution and Article 296. And the question we always ask, which we would like to reiterate today, is that why must we go through all these tedious processes just to get a public officer who we pay as citizens of this country, a public officer who has discharged a certain constitutional duty by conducting elections and declaring the outcome of same? We are talking about G. Mensah, the returning officer for the 2020 presidential election. Why must we go through all these hassles, all these troubles to get this woman to just give account of her stewardship, how she did her job, and how certain things happened, so that the courts can know the truth in these matters and do justice? If she has nothing to hide, if she has done nothing wrong, why must we go through all these tedious processes? Now, there were questions about, oh, but you close your case voluntarily. Yes, we close our case based on the representations of the EC chairperson that she was going to be available for cross-examination. And at the time we were closing our case, we could not have subpoenaed her to testify because she had filed a witness statement and several affidavits which had made it clear that she was going to testify for the first respondent. And so the law and the rules of this court would not have allowed us to even subpoena her at the time. So this issue of, oh, you close your case voluntarily, you cannot, no. The last time, the president of the bench stated clearly that it is a settled principle of law that a party can apply for leave to reopen his or her case after he has closed his case. And that is what we have done, and we believe that we have demonstrated that the circumstances or the conditions which are important for such, for leave to be granted in such circumstances have been demonstrated. The court dismissed this application and said basically that we failed to show the reasons why we were seeking to subpoena Madam G. Mensah. Now, because of time, I will not go through our statement of case and order, but you can check paragraph 28 and paragraph 42, and you can see for yourself that counsel for the petitioner and the petitioner explained clearly why we need G. Mensah to enter the box. We explained that she is the returning officer who made a declaration of 9th December. It is she who claims to have made errors. It is her outfit which purportedly sought to rectify that error through unlawful means. It is this same returning officer and her office who have sought to churn out conflicting and inconsistent figures. And that it was important, among other things I would say, it was important that she be made to enter the box, cross-examined, so that the truth in these claims could be unearthed for Ghanaians and the court to appreciate all these things. So we disagree with the court that we did not show why we are seeking to subpoena G. Mensah and the usefulness of her testimony to the determination of the issues before the court. We believe that the evidence before the court shows that we did that. Again, the court, in interpreting section 26, commenting on that, said that, oh, there are certain conditions when it comes to promissory estoppel. Now, it's instructive to note that counsel for the second respondent, Lawyer Kutampa, had suggested that G. Mensah didn't even make any representation to us that we could have relied on. And that what G. Mensah did was basically to state the position of the law that she will be available for cross-examination. That was not a representation, was not an undertaking. Those were his words. Now, the court in this ruling says that it is a representation, but same cannot be said to be unambiguous. In other words, it is ambiguous. We have read those depositions over and over again. Those depositions are undertakings. Per section 26, G. Mensah is bound by same, and there is no ambiguity in those depositions. She says clearly that the petitioner will not suffer any prejudice or injury because the petitioner can solicit the answers he is seeking through interrogatories during cross-examination. And we believe she meant what she said. Before I conclude, again, the court spoke about section 72 of the Evidence Act that counsel argued on in this case. And the court said that there is no inconsistency between the Black Law Dictionary decoded and Section 72. Yet the court still stands by its definition of who an adverse witness is, that a person must enter the witness box before he or she can be described as an adverse witness. Clearly, you can all download the Evidence Act 1975 and read Section 72 for yourself. It says that, among other things, a person whose relationship to a party makes his interest substantially the same as a party may be called. So you can be called to enter the box as an adverse witness. You need not be in the box before, on the basis of your adverse testimony, you are described as an adverse witness. And so there too we disagree with the court. But ladies and gentlemen, a lot happened today. We do want to bore you with all the details. The bottom line is that the petitioner is worried that the courts, in deciding these applications, are not applying statutes that have been passed by our parliament, and statutes that the court has been applying in other cases. And we think that the petitioner is being denied a fair hearing, and it is important that these issues be pursued to their logical conclusion. Now, why are we doing all these things? We are doing these things because of the constitution that all of us as Ghanaians have agreed to be bound by. Article 63.3 of that constitution says that no person should be made a president until and unless he attains more than 50% of the total valid votes in any presidential election. And it is clear from Jim Mensah's own declarations and the figures contained therein that candidate Akufo-Addo did not get more than 50%. We've done the mathematics here over and over again, and you can do the mathematics yourself. He did not cross. And so the petitioner, John Dramani Mahama, His Excellency, is doing this for and on behalf of all of us, and he's doing this in defense of the Constitution. And so we must all be interested in this case. Let me appreciate those who have been encouraging us and cheering us on. We really appreciate your encouragement, and we are assuring you that we are not giving up, we are not giving in. We are fighting this matter in the interest of justice and for God and country to its logical conclusion, so that tomorrow an EC chairperson or an EC will not arrogate to themselves the power to choose leaders who have not met the constitutional threshold that we have all agreed to work with. We don't want that bad precedent to be set. The will of the people must always hold sway over the will of a select few. And for those who are crestfallen, those who are discouraged, and sometimes call us worried, disturbed, why don't you withdraw this matter? Why you shouldn't even go to court? We want to tell them that we understand and appreciate your frustrations. We understand and appreciate that. And we are telling you, don't give up. We are not doing this for nothing. We know what we are doing. And we are doing this because of the love we have for Ghana, particularly that of the petitioner. And so let us all be patient with the legal team as we go through the process. We are not abusing the court processes like some are suggesting, and we have not defied the orders of the courts. Everybody knows that any party dissatisfied with the decision of the court is entitled to a review. And so we are just using processes provided for under the laws of this country that we have all agreed to be bound by. And let me just say finally, like I said last week, that no matter how this case will go, no matter how the decision will go, because we are all discerning, because we all love the truth, because we are all following this case keenly, the truth will become clear to all of us, and we will all see the truth. And don't always think that when people come to court and the applications are dismissed, it means they are wrong. No. What it means is that the court is right for the time being, and it is what the court has said that will prevail. Like now, we disagree with the court, but whether we like it or not, what the court has said is the law, and that is what will prevail. But posterity will be the judge of us all. Just like it happened in the case of Ray Akutu, when the Supreme Court then unanimously dismissed the case brought before it by Joseph Dankwa, J.B. Dankwa, with regards to the unconstitutionality of the Preventive Detention Act. Today, even though the court held in that case unanimously that the presidential oath was akin to the coronation oath of the Queen of England and didn't constitute a Bill of Rights and all that, today what is celebrated is not the court decision. In fact, that is the most unpopular decision in the history of this country, even though it was a unanimous decision. What is celebrated are the submissions of J.B. Dankwa. And we believe that posterity will be will judge us very well. Will judge us very well. Now, we are hoping, based on the indications that the court has given, that they may find it necessary for counsel to be given the opportunity to make some submissions, oral submissions, on the written submissions they have been asked so far. There's not been any clear indication to that effect that will be done, but the court says that if it finds it necessary, the court will do so. We think that looking at the considerable public interest in this matter, it will be important for that to be done. But if the court, in its wisdom, decides that they are not going to allow counsel to make any oral submissions, we will respect that, and we will be engaging you in the media, and we'll be sharing with you the content of counsel for the petitioner's written submissions. And so that's where we'll end it. If you have any questions, you can ask. Of course, in 2013 it was done, so we are hoping that that precedent, which is a very good precedent, will be repeated in this case.
Thank you. Two quick questions. The ordinary bench and the application to reopen, a 7-member panel, dismissed the application. We have an enhanced panel, 9-member panel, equally dismissed the application. Obviously, from what you have said, you are dissatisfied with the decision, but you have to file your address anyways, and you would have to do that, close the case, file your closing address without the benefit of the testimony and cross-examination of the EC chairperson. Question number one, are you disappointed? Question number two, is the NDC going to be seeking another opportunity to hold her accountable, as has been the talk all throughout?
Okay. So the first one, are we disappointed? Yes, we are disappointed. We are disappointed that, in our opinion, the petitioner is not being given a fair hearing. We are dissatisfied that, in our opinion, it appears that the EC chairperson is being shielded. We are dissatisfied that, in our opinion, and as articulated by counsel for the petitioner, known principles of law and statutes that our parliament has passed, that the court has previously applied, are not being applied to this case. So, in our opinion, we are not being treated fairly, and we are disappointed. But the decision of the court is what prevails. And to answer your second question, are we going to explore other opportunities or avenues to hold her accountable? Emphatically, yes. We will explore. We mean it when we say we will explore all options and fight this matter to its logical conclusion. Any other question? Okay. So, Baba will do this.
Yo, anyone, I say, ne court by no, in Sembe, you know, and a sea or court her. Yedi kan em say a system free twemu court si ginae bi ginae o si ni so on my ho kwan me mie yasem no mu sene ye be ye betimi afra ma meje mensa na waba abeka nanu mu nsa no wa kye ni esi wo abatro no enne ye samba say court nsan hwe ni ginae ne biom esan say yen ya dwumu de enim se ma meje mensa wa ma no kura wa asem ye hunu ono ana or declare election no or no ana o my figures different or no ana chirese na na kufu ado wini a yen susie mu ne nkunda buo mu no na na kufu ado wenya 50% plus one wenya enjiti e ba be kansem na so wono amma amaka bidia na jesa asem na kan no na anwie feyo ye kai no mu nsem biara na so court no ene ye anya adwen court no enyina ene se ono de ofo se ma me di mensa ba enye yi saa semi ene asem esi o court na ye ne ye gusu agina bebi agina se court na kasa de na ne court no so beka ene ye mra be no so nkyere se be za woni court na adua wontimi nka wasem eye mi nua kasa no oma decision bi a emre bi court na si agina ya court nipa na wo hoyi na ka se ni oma kan na enukure na nsi ebe chire no na asem no asesa endi ye didie mu de enim se asem na ye kono ne court kan ye no wa kan de na ye nso ye no mu ya adwen ye be se ye Ghana foi na bose ne ye no enya se ye no kwa akwa ye ni si enim ne ye Don Dramani Mahama wotunu wasi ho so obabuo mu obiara
court nsema waka obi atiase wetu no wagina ho se no kura wasasem no mu e wo se pie enti se obi gina ho no okase bi o adentina mo koso ye adentina mo nya ne pese obi atiase ne se John Dramani Mahama ogusu gina bebi ogina ne ebeye biara kwan bi foforo bia wo ho na o se ye faso mama me no beka na num nsem ma no kura no de di magana 40 a inshallah ye do mbeba. Salamu alaikum jamaa. Yau kuma mun zo court inda muka zo court abinda muka gani yau shine matan da ta saya aka yi wanga takara, matan muna so ta zo ta shiga cikin takaran, ta shiga cikin adaka ta yi magana mun yi court wai bai rayu da mu ba. Amma abinda muke so jama'a su gane ba wai ka zo court na ka yadda maganan ka ya kare ba. Akwai hanyoyi da yawan da za mu bi ba kuma abin da za mu bari ba. Za mu ci gaba inda za mu bi matan ta shigo ta bari jama'a su gan gaskiya a me ya faru, domin ita ta zo ta yi declaration nan, ita ta sai aka yi takaran abin da aka yi duka ita ta yi, to don me za zo yi magana a ce babar ta shiga a daka, don me za zo a kawo magana ta ce ba yadda. Yau mun zo kotu wai bai yadda da mu ba, amma abin da muke so mu gane in kotu bai yadda da mu wannan bai gwada kan magana ta kare ba. Za mu ci gaba inda za mu bi magana ta kwanta, matan ta zo ta faɗi gaskiya ko yau ne ko gobe ne ko zuwa gaba ne, za mu bi mu bar ta zo ta yi gaskiya. Assalamu alaikum.
Please, Dr. Ayine will address you briefly. So.
Madam, we stand by. Let's all stand by him.
He's coming.
I'll stand.
Okay. Thank you.
I'll stand beside you. I'll stand beside you.
Okay. All right. Yeah.
Let's
okay. All right. Good evening, ladies and gentlemen of the press. I am here this evening in respect of the remarks that are made to you on the 16th of February after court proceedings. Those remarks were widely publicized by the media, and both mainstream and social media carried them and they went viral. I have looked at what I said that day, and I have come to the conclusion that I went overboard, I crossed the line with respect to the remarks that are made in terms of attributing impropriety to the Supreme Court of the Republic of Ghana. And I just wanted to let you know that this morning I delivered a letter to His Lordship, the Chief Justice, offering an unqualified apology to the court. Now that letter has been filed and the Chief Justice of the Republic has referred to it, I want to take the opportunity to read the content of that letter to you, and thereafter I will apologize and retract my words. Now, the letter reads, My Lord Chief Justice, summons to show cause unqualified apology to the Supreme Court. On the 16th day of February 2021, I addressed a press call at the premises of the Supreme Court in respect of a ruling that the court had rendered on that day. I did so in my capacity as a member of the legal team of the petitioner, with instructions to brief the press on matters of concern to the petitioner after court proceedings. In carrying out my instructions on previous occasions, I had always made certain that I explained the day's proceedings to the understanding of the press corps and of fellow citizens with civility, and without seeking to attribute acts of impropriety to the Supreme Court or the respondents. On the said day, I thought I had maintained that approach to the press briefing, but on hindsight, I actually crossed the line in suggesting that the court had a predetermined agenda, among others, to rule against the petitioner. My attention was drawn to this fact immediately after the press briefing by Frank Davis Esquire, to whom I am grateful. It was not my intention to scandalize the court or to bring it into disrepute. In the circumstances, I wish to apologize unreservedly to the court. Yours sincerely, Dr. Dominic Akuruting Ayine, signed. And for those of you, I'm sure Mr. Frank Davis is not a stranger to the press. He's standing here to my right. I remember on the 16th of February when I finished addressing the press, he walked up to me and reminded me that the phrase that I had used, that there was a predetermined agenda, had crossed the line. And that is when I started thinking about whether or not I had crossed the line. And I agree absolutely with Mr. Frank Davis and those of you who think that I crossed the line on that day. I wish to unreservedly apologize to the court, that is the Supreme Court of the Republic of Ghana, as well as the justices in particular who sat on that day. There was no intention on my part to impugn their integrity. I was just expressing a sentiment with respect to the ruling of that day. And I want to render an unqualified apology and to retract the words that I used on that day in their entirety.
Unreservedly.
Unreservedly, I will not in any way want to disparage the Supreme Court of the Republic of Ghana. You can see I'm lost for words because I don't want to be, when you want to take a pegative, I was told that I should peg myself of the contempt. So you take the pegative so that you don't complicate the constipation. So I'm being very careful that the pegative I'm taking this afternoon will not complicate the constipation. And so I wish to thank the press for the opportunity to address you, because His Lordship the Chief Justice, in making the order, said I should use the same medium that I used in conveying the words that are the subject matter of the contempt proceedings. And so thank you very much, ladies and gentlemen of the press. I am hoping that my apology and retraction will be accepted by their lordships, and the matter will come to an end. Now, in respect of this matter, I plead with the press that I won't take any questions and provide any explanations. God bless you and God bless our homeland, Ghana. Thank you. Thank you.
Colleagues, good afternoon. We'll make it pretty snappy because we can tell that you have a big story today, bigger than all that has happened in court. So we'll make it pretty snappy. I think you have followed for the several hours of today the legal arguments that were made by counsel for the petitioner and then responded to by counsel for first respondent, counsel for second respondent. I think at the end of the matter, I want to draw your attention to the words of the Supreme Court speaking through His Lordship the Chief Justice in ruling. And I want to focus on that because lawyers express their opinions on the law, what they think the law means, what they think a proper construction of the law ought to mean. And I think today you are noticing that our friends on the other side now keep using the phrase that in our opinion, in our opinion, in our opinion. Initially, the argument was as though it was fact. But you notice that the point is being made that people express opinions, the court determines in the end. The court has said that the legal arguments, the provisions of some of the acts and the CI and some of the authorities that the petitioner's legal team tried to invoke together with the principles of equity, and if you just listen to the court, it says that the positions that they were expressing are not supported by the law or the principles of equity. So even a reiteration of it before the press and a re-explanation does not change the fact that the law does not support the position that they've been expressing. And so we will not go into a reiteration of all the legal arguments that we made. I think this is about the third time that the court has dealt with this type of issue and has come to a certain conclusion on it. The court also says that they did not satisfy even the minimum threshold required to sustain an application of this nature. You know, sometimes when we make this point, it appears as though we ourselves are saying it. We are not the ones saying it. The court, I think this is the third time that the court has made the argument that the law does not support their position. They have not met the legal threshold. So we are not the ones saying that what they are saying does not align with the law. For someone to say we are disrespecting our seniors, etc. The court, the Supreme Court of the Republic of Ghana, is the one that is making the point that they have not satisfied even the minimum threshold. So we won't bore you with too much detail. The court has decided that on the 4th of March, judgment should be delivered in this matter. This is after the petitioner who came to court, among other things, arguing that nobody won this election, has called 3 witnesses, and has now, I think in the last 2 or 3 applications, been praying the court to literally force the EC chair into the box so that he can reopen his case and advance something else which he hasn't told the court, something else that can help make a better case for him. The court has decided that despite its earlier warning that if its processes are not complied with, it can strike out the matter, it will still accommodate them so that they can file their written addresses. I think this is clear evidence that nobody's being denied a fair trial here. The court has bent itself backwards and is accommodating the interest of all parties. So we look forward to the 4th of March for judgment. If it is the view of the court that they want to invite our lawyers, viva voce, to address some issues, they are more than prepared so to do. But Ghanaians have followed the journey that has gone on so far in the courts, where the petitioner was being looked to adduce the evidence. I heard our colleagues here saying that the mathematics is clear, but you have been here covering for all the days that we have been here. And I'm not sure that to you saw mathematics that yielded results other than 47% for the petitioner, Mr. John Dramani Mahama, and 51.2 for the second respondent, Nana Addo Dankwa Akufo-Addo. That was the mathematics that you saw Mr. Johnson Asiedun Ketia arrive at. That was the arithmetic that he arrived at, the answer that he arrived at when he did the various computations. Today you are hearing them telling you that the mathematics is clear, nobody crossed the 49%. But in the wells of the Supreme Court, before the justices, and I'm not sure you have seen them prove that. But in any case, we'll come back on the 4th, and then we'll stand by for judgment. So we'll keep it simple. We'll take your questions, and when I'm done, my colleague Nana B will do a quick Twi translation, and then Faisal will do a quick Hausa translation for us. We're going to take your questions.
Sami Jenfi stated that after this proceedings, if unfortunately the ruling goes against them, they're going to use any other institutional measures to still bring out the fact that they need from the EC chair. I want to ask, are you also ready to counter all the...
So for those who didn't hear the question, his question is the admission by the petitioner's team now that they are willing to explore other avenues for the so-called accountability and truth that they talk about. First of all, let us reiterate that the truth is what has been laid before the court. The truth is what has been gazetted. That Nana Addo Dankwa Akufo-Addo, when you add the 38,000 plus polling stations, or you add the 275 constituencies, or you add the 16 regions, the truth is that Nana Addo Dankwa Akufo-Addo crossed with over 500,000 votes as a margin. It is the petitioner who seeks to challenge this truth, but has not brought his truth to court. Whatever counter evidence that he may provide to cause even the chair of the first respondent to get into the box, I'm not sure you have seen it here. But today they are admitting before you that they are willing to explore other avenues of accountability. Remember, about 2 weeks ago, we've been arguing before you that if you want accountability, generally, you can come to Parliament. There are parliamentary committees of inquiry that can look into whatever matter you bring. And there's a 137 plus 1 Parliament. You can come to Parliament. You can come under the Right to Information Act asking for some particular information. If it's judicial review that you want, that you think that the EC has not done something specific and the courts must bring its power to bear on it, the high courts are there for judicial review. So it is interesting that at the end of the case, when we are all wondering where the evidence that they were supposed to provide to back their case is, they are now opening up to you that they are willing to consider other platforms of accountability. We'll see which ones they choose, what case they make, and if there's any adverse arguments that need to be made there, we'll respond accordingly. Are there any other questions? Like I said, we know the big story that you have today, so we won't bother you with too much talk. Nanabi?
Yes. Abusiafo ene omana de hye e bedamase senia minia kwadwo oponkroma abo ne tofa no saa na menso mikura no epo be enum nia edikan mobekaya na no ana kwadubofo de tudwa se enka omasema nanka omatumu epono na omabo mu nkro nyina wie na omo nsem ni nyina no omo se omaka amanasa oma dansefo enso asa ekowie akire no omo se awose yetwe Mami Jane Mensa ebegina adaka mu ansa na omasem no asipi na asita anunti omo pe ekwan afri court ho court mo omo kwan no mu mie omasem nani no mu bi omasem nani nso a Omasa de atukot anim sa court enhye Mami Jane Mensa na ombegina adaka na yentoto na no obekaya eno court empanifo nso nyina omadwen ekọ benkrom ema omo ka se dabi enya ade ombema kwan amakọ adubofo e petitioners no omabie omasem nani eno achi ena asem ebeto odwa ne se omosa de adesede sa beto eye Supreme Court anim se asamo na no omo kan se nkomo makwan emom mbie omasem nani no omo sere omo nsan sacha omadwene sanse emra bi ho no a omo amfa anya adwuma ene court achirechirem se ansana obeba Supreme Court se omo nsacha omadwene no enya kwa ena enya se oma oniema so anu abase yen sacha yasemani awosa wo kire se na ade poten ade sonko ade nwanwaso bi wo hono a onsanka ebra na yedi asem no na saa ade nwanwaso no ama tentene ene pepepe yo akadwam eno kwadubofo na ntimi ankere na ye nanu komobo na omo kan no eno ano mo saka dada no a asem fufuro bia eni ho eti court esa akọ obekaya ene empanifo mienu sa beka ho mo ye nkono empanifo nkono nyina se esema mo de baa no eni nyina so emramu ye nhu ye enu ntino ye ntimi ema mo kwan ma mo nsam bie mu asem nani na emom nyame ya adom a ya hye busumia e ba be wuramu eda etoso 9 4th March ye de yatemu eba entino obibia nko na abekai so a ade ba ko na kodubofo ne kapa na medi twato ene se court betie na court atie omuye na omu nsam omu wonyina no ombetimi aka ne emramu ye fe no fair trial abusuam bekaya ye hye asem ne yasi court atie asem ne ye pa ebra omu ye mfom so kra omu kratam court mo kwan mo kosiesie de bae aye ensemfo no mo so beso mo de pimpim easy ye mo kwan yete omo applications ahodo mo de ababeto court anim court atie omo se okinkan a applications a omo de abeto court anim eye enson ni nyina court no aboagu sanse omasem no eni nyina so etinyame ya adomo a ye sai be hia e wo ha sei busumi a ebewura mu eda etoso 9 na asɛm a ya na metateɛ ɛne sɛ yenuanu mendisifo omunya rehemu sanse asɛm die ekoye mesrɛ so muntimi ɔmade so a momo mfa nhyɛ ɔmo kashiri ɛna no pɛ mekai sɛ metie ɔpani baako alaji nusa fuseni ndc ni mapa ɔso ɔno kra wapa aba sanse asɛm no ensuo bia enyinam tebusuanfo meda mo ase na ansa na menua feza de hausa de no bebrɛ mu no mɛsɛ ne mpanifo abɛka yɛn ho ɛne yɛn hyɛ bia ma agye sɛ 4th March nti mo fama so mfɛm me yɛ chairman yɛ pani a odi anim chairman makmenu ɛne ɔka yɛn ho ha ɛyɛ ɔno ana saa yɛ star witness ɔno egyina mu ma ɔmampani nana ado dankwa ekufo ado lawyer Joyce Opoku Boateng nso ɛka yɛn ho ɛwɔ ha sei ɛna Hajia Fatimatu Abubakar Esquire ɔyɛ lawyer ni mapa ansana mia menua kwadwo Ponkruma minister designate information okodada ɛna ebiemu nso nana adwoa adobia Asante Kati Mrs. enso ɛka yɛn ho ha say lawyer ɛna Evans Nimakon director in charge of elections and research ye penny baako director of communications or now say lawyer Nimapa osaka kasama for ho lawyer ya oboaben asamwa enso ɛka yɛn ho ha ebiem Patriot Fraser enso lawyer Nimapa no so kan yɛn ho lawyer Lenin ɛka yɛn ho ya lawyer for nkuma ɔmo so boa research enso kan yɛn ho ha lawyer K Amoa enso egyina kyire ho ansana Niamate enso ɛwɔ yɛn nkyɛn wɔ ha ebiem the president's lawyer lawyer Ko Esuman ɛna lawyer Hajia Hamida Nuhu omunya kan ho lawyer Akutampao lawyer Frank Davis lawyer Shila Menkampremo lawyer Kweku Esrifi lawyer Yaw Opon lawyer Yaw Ado lawyer Victoria Bath lawyer Ochiri Ejekum lawyer Dr. Ernest Owusu Dapa Enna your head of technical team the fearsome and the intelligent Joe Anoche Nyamishamo Patriot Rabbi Janefa House and Bom
to yawa na fara da gaisuwa mai kanshi assalamu alaikum wa rahmatullahi ta'ala wa barakatuh yau da muka zo court abinda ya hafku ne lawyers for John Dramani Mahama suka zo da abasu anya an so su da ke to ina kai ku baya kadan bayan da muka jefa kuriya December 7th the electoral commissioner ta fito ta bayyana results shi ya NDC suka zo suka ce an sata elections da muka yin nan sai suka ce kaman a'a su suka ci uku tuna waransu kaman fita otukuno sun fito har sun ba da figures da percentage da ke gwadawa kaman sun ci elections John Dramani Muhammad da kanshi shi ma ya fito ya ce election da aka yi ya ci Sami Jenfi kuma ya fito har shi ya declare John Dramani Mahama kaman shi ne president elect da general secretary su Asedu Ketiya kuma shi ma ya fito ya ce kaman elections da aka yi su suka ci amma da suka zo court shi suka sake bakin su suka ce a'a ba su ci ba amma election da aka yi nan ba wanda ya samu more than 50% of the valid vote bi mana in aka raba vote da aka yi in aka raba cikin biyu ba wanda ya samu more than 50% isa na bai fi a declare president Nana Ado Dankwa Akufo-Addo president ba da suka so suka file wannan petition sai haki ya zo kansu domin in kai ka ja wani ka zo court kai allegation kan me shi ya fi ka kawo hujjanka da shaidanka da ke gwada kamar allegation da kai nan gaskiya ne to shi the court zai duba ya rule ibaka amma da suka zo suka kawo shaida guda uku witnesses uku Asedu Ketiya Dr. Michael Pesa White da Rojo Metodunu da suka zo maganar da suka yi da suka shiga cikin adakan bai gwadawa kamar allegation da suka yi na akwai hujja ciki to shi lawyer su ya tashi ya ce ma court kaman shi kesin ya kare kesin shi shaka tambaye shi ka kare wai na kare kesi na aka ce in ya kadan ni court ya bada anya kama EC da team president Akufo-Addo mun bude kesin mu shi muka ce in ka duba evidence da suka kawo hujjan da suka kawo bai gwadawa kaman su ya sun justify allegations su isa inda kana ne mu dai ba mu kawo mu namu to shi lawyer kuma ce bai yarda inda kana ne yana neman a sa ma EC ce igiya wuya an so a jawo ta a kawo ta a cikin adakan to shi court ya ce bai yarda shine yau suka file for review yau kuma court ya gwada kaman a'a ba wannan anya to wuri muka kai yau court kuma ya ba da date 4th March in Allah kai mu da mu zo a ba da final judgment isa in Allah kai mu on the 4th of March mu zo danga an so mu zo mu ji final judgment. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.
Those were the two press conferences, and of course we also did witness that apology rendered by Dr. Dominica Wujayini. But let me quickly remind you what happened in court today. First of all, in court today there was the hearing of the application by the petitioner for a review of the court's decision which was taken on the 16th of February. That decision which had to do with the petitioner applying to be allowed to reopen his case. Of course, the decision of the court was that the petitioner, that application was dismissed by the court. Then the petitioner's lawyers then appealed to the court to review that decision, which is what the court considered today. Of course, lead counsel for the petitioner, Mr. Chatuchikata, advanced his arguments drawing from very many legal authorities to back his appeal for that review. As was expected, lawyers for the first and second respondents, Mr. Justin Amenuvo and Mr. Akotampao, respectively, also objected to that application, also citing from several legal authorities and backing their claim as to why it would not be proper for the court to grant that application. The court went on recess for more than an hour and a half, and when the court returned, the decision was that the application had been dismissed. Following that, we also did see that the petitioner had made an application to the court to also put a stay on the proceedings. The petitioner then withdrew that application, and then the court announced that on the 4th of March is when it has slated for final judgment. However, after that, the court then called Dr. Dominica Wujayini, who was deemed to have made some contemptuous statements, and he did apologize in court, and the court then instructed him to use the same platform on which the contemptuous statements were made to retract and purge himself of that contempt. Indeed, during the press conferences, which usually is addressed by spokespersons of the legal teams, Dr. Wujayini then came, and that was the same platform he used to make those statements against the court, and retracted unconditionally and apologized unconditionally as well to the court. The court has told him to return on Thursday for the whole matter to be struck out after he had rendered this apology. Basically, that's what has happened in court today. Final judgment, the court has indicated, will come off on the 4th of March 2021. Have a very good day. My name is Abdulhai Momi.
had already claimed that the petition itself disclosed no reasonable cause of action and had already filed a preliminary legal objection to that effect. And so the depositions that she may be available or she would be available for cross-examination, and those questions that the petitioner sought to serve by way of the interrogatories could be asked of her when or during cross-examination if the petitioner so chose, was in light of the preliminary objections that the respondents or the first respondents in this case had already filed, that there was no reasonable course of action that the petition disclosed. By virtue of that statement or the statement contained in the depositions were not unequivocal, unambiguous, not clear and unconditional to meet that threshold that will require the statement to be conclusively presumed against her.
All right.
The court further went on to talk about the fact that cross-examination was only possible when there was examination in chief, and that statements that are made under the position in an application, in opposition to an application for me to, for instance, serve interrogatories, could not then have been unequivocal. Then the court moved on to deal with Section 72 of the Evidence Act arguments, the provision that talked about adverse witnesses or adverse witness in a civil trial, and dealt with the issue of their reliance on Black's Law Dictionary, and ruled to the effect that there was no inconsistency between the Black's Law Dictionary definition of an adverse witness and the provision contained in Section 72 of the Evidence Act. And importantly, the court suggests that it is the nature of the testimony of a witness that will make the witness be deemed to be an adverse one, and not necessarily a party's characterization of that witness. Simply put, the court was suggesting that if you look at the provision of Section 72, the dispositive part of that provision is the general idea that it is possible for the party to call a witness, albeit at the discretion of the court. But the dispositive provision is not the party's characterization of the witness as an adverse one. The witness must actually, in fact, through his testimony, be deemed to be an adverse one, not simply because a party is saying that I want adverse witness. So we saw that the court cited a case, I believe it was in re Okine, and talked a little bit about it, and then concludes that they did not see any fundamental error in the ruling by the description of the EC chair as an adverse witness by the petitioner, simply because of that. And the petitioner actually continues to not disclose the new evidence that the EC chair will provide and how that will impact their case, as they had already ruled in their earlier ruling. The one that was this review was in relation to that you needed to show the evidence that you are bringing forth, whether it was capable of getting it during the initial stage, and how that will impact the case. And you remember the court in that ruling suggested that the petitioner had not given it any inkling of the evidence they sought to adduce to the EC chairperson. So they basically reiterate this point and suggest that, and then they move on to deal with the other grounds on the exercise of discretion, that the petitioner had failed to draw the court's attention to any inappropriate exercise of their discretion, and that in an adversarial system, which we have in Ghana, as opposed to the inquisitorial system, parties to a case in a court must know exactly what they are required to answer, and that is a requirement of fair hearing. And so the respondents, having closed their cases after the petitioner closed their case, if the petitioner sought to reopen its case and adduce fresh evidence, because that's the natural consequence of reopening the case, which the petitioner made it clear that they wanted a subpoena to be issued so that the EC chairperson can testify, which would mean that the purpose for reopening the case is to adduce fresh evidence. So in seeking to reopen a case, the petitioner must show the evidence that the chairperson of the EC was going to provide generally, which the court believed they had failed so to do. The court also talks about the fact that statutes must be read in whole, not in piecemeal, in the sense that you must read the Evidence Act as a whole, not necessarily choose provisions that may ostensibly buttress your point. So in that regard, the court talks about sections 10 to 14 of the Evidence Act, which lays down the burden to produce evidence and the burden of persuasion, which is on the party that is making allegations. So in an election petition of this nature, the party that has brought the petition essentially claiming that Article 63.3 had not been complied with, in the sense that no candidate had met the constitutional threshold of more than 50%. That party bore, at least initially, the burden of persuasion, that is to convince the court that the fact that they are alleging is true, to avoid a ruling on that against them, as well as the burden to produce evidence to substantiate the allegations of fact that they are making in their pleadings, that indeed no party got or met the Article 63.3 threshold. And it was in this relation, or in relation to this, that the court cites the Mechanical Lloyd case. And the Mechanical Lloyd case, I just shared the ruling, or the part that the court referred to, and I'll bring your indulgence so that we read this out, because the court actually read this out. And the case is Mechanical Lloyd Assembly Plant and Nothing. It can be found in 1987-88, 2 Ghana Law Reports at page 598, and it's a Supreme Court decision. And this is what Adade JSC, who was a justice of the Supreme Court then, said. Let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment, and the Privy Council used to be the highest court in terms of the colonies, so that when you exhausted in the various colonial administrations, like in the Gold Coast, you could further appeal to the Privy Council, which sat in England. So he goes on, a Privy Council judgment put in the hands of any lawyer, along with the evidence grounding it, can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision would be right. So if he lost, how could the court be right? Be criticized is no ground for asking that it should be reviewed. The review jurisdiction is a special jurisdiction to be exercised in exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in the exceptional situation where a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor is it an automatic next step from an appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment, end quote. And that is what the court cited the Mechanical Lloyd case at the JSC's summation of the review jurisdiction of the court. So the court reiterates that the review jurisdiction, which has been given to it by virtue of Article 1331 of the Constitution, and the grounds for which you can see the review can be found in Rule 54 of CI 16, is a special one and not equivalent to an appeal. And that the application that the petitioner brought, which was not based on any known law or the rules of practice, and according to counsel for the petitioner, was grounded in the inherent jurisdiction of the court to correct errors and things of that sort should and was dismissed as not being meritorious. So that was the first part of what we saw in terms of the ruling that the court gave today.
Right, so I think we'll be preparing to wrap up, Doc. It's been a very long day. But after that ruling, there was also a motion by the petitioner to